Hello viewers, this is Aravindar Annai Arul channel welcomes you. How are you? In this video we have to see women can't be denied employment saying work involves night hours. Kerala High Court cautious only males can apply conditions. So for getting more information we shall go to the inside of the video. I request to all the viewers to kindly watch this video in full. Now we shall go to the inside of the video. Kerala High Court observed that a woman who is fully qualified cannot be denied of her right to be considered for employment on the ground that she is a woman and because the nature of the employment would require her to work during night hours. Protective provisions cannot stand in the way of a woman being considered for employment for which she is otherwise eligible, Justice Anu Sivaraman observed. The court set aside an embargo contained in a job notification issued by Kerala Minerals and Metals Limited, which allowed only male candidates to apply for the post. The court said that the said embargo is violative of the provision of Articles 14, 15 and 16 of the Constitution. It is the bounden duty of the respondents who are government and government functionaries to take all appropriate steps to see that a woman is able to carry out the duties assigned to her at all hours, safely and conveniently. If that be so, there would be no reason for denying appointment to a qualified hand only on the ground that she is a woman and because the nature of the employment would require her to work during night hours, the court said. I make it clear that such protective provisions cannot stand in the way of a woman being considered for employment for which she is otherwise eligible, Justice Anu Sivaraman added in the order. Trissa Joffin, an engineering graduate in safety and fire engineering, was engaged by Kerala Minerals and Metals Limited, a public sector undertaking under the state of Kerala, as a graduate engineer trainee safety. She challenged a notification inviting applications for the permanent post of safety officer available in the company to the extent it stated that only male candidates need apply for the post on the ground that it is discriminatory and that her right for being considered for appointment as a safety officer is violated due to the said provision. She also prayed for declaring Section 66 1B of the Factories Act 1948 is unconstitutional as violative of Article 14, 15 and 16 of the Constitution. The said provisions stipulates no woman shall be required or allowed to work in any factory except between the hours of 6 a.m. and 7 p.m. The court in its judgment refers to various earlier judgments in which it was held that the provisions of Section 66 1B are beneficial in the nature and are intended to protect women for exploitation. In the factual situation involved, we have to consider the fact that Factories Act 1948 was enacted at a time when requiring a woman to work in an establishment of any nature, more so in a factory during night time, would only be seen as exploitative and violative of her rights. Apparently, the world has moved forward and women who were relegated to the roles of homemakers during the times when the enactment had been framed have taken up much more demanding roles in society as well as in economic spheres. We have reached a stage where the contributions made by women in the spheres of economic development cannot be ignored by any industry. Women are being encouraged to work during all hours in several industries including healthcare, aviation and information technology. Women have been engaged in several professions requiring round the clock labor and have proved themselves quite capable of facing the challenges of such engagement, the court said. The court also referred to recent Supreme Court decision in Secretary Ministry of Defense v. Babita Punia and others 2027 section 469 has declared that an absolute bar on women seeking common appointment violates the guarantee of equality under Article 14 of the Constitution. It was held, the court noted that submission based on stereotypes premised on assumption about socially ascribed roles result in gender discrimination against women and violate their fundamental rights. In the present scenario, to say that a graduate engineer in safety engineering cannot be considered for appointment as safety officer in a public sector undertaking because of an offending profession under section 66 1b of the Factories Act, according to me, is completely untenable and unacceptable. This is evident from the fact that the state of Kerala has approved an amendment to the rules which permits the engagement of women on condition that all safety precautions and facilities for such engagement are arranged by the employer. The judge said, "Hello viewers, you gathered this information. Women can't be denied employment saying work involves night hours. Kerala High Court quashes only male can apply condition. This information may be useful to you." The Aravindar Annai Arul channel thanks to all the viewers to watch this video in full. Thank you very much once again.